I am Advocate Aditya Kedari, and my topic to me is safeguarding against reprisal actions. So first of all, I would like to just introduce that see, sexual harassment is not at all acceptable anywhere, with whether it is workplace or anywhere. It's humiliating. It's a traumatic experience, and majority of the victims are the ones who are afraid of a backlash or some kind of a retaliation from the respondent or from the organization as a whole if you speak out. Normally, the aggrieved woman or the victim is looked upon as a troublemaker when that person goes and files a complaint for sexual harassment. So, in that, even today, it is happening. So, normally, due to this fear, many women are the ones who are not ready or are afraid to go and file a complaint. Now, that's the reason why we as trainers have to go and encourage women to speak out. All right. But at the same time, it's very much important to protect the victims from any kind of reprisal action, that is retaliation from the overall organization, from colleagues, from the respondent, from all that different type of people. Now, PoSH, that is Prevention of Sexual Harassment Act 2013, has certain provision to protect the victims. All right. Now, that important factor I'm going to go, it's linked to confidentiality of the victim or even the respondent and the witnesses which are involved, so that there is no misconduct happening whenever the trial or whenever the investigation is happening. All right. Now, first of all, let's discuss some of the reprisal actions or what kind of retaliation can happen. So there can be the person can be dismissed, the victim suspended, transferred to less favorable department, negative performance reviews, important projects, that person will not be involved, that person will be threatened, that person will be compelled to take back the allegation, that person will be terrorized, that if you go further with this proceeding, it's life-threatening calls, people coming and asking uncomfortable questions, what happened, and overall gossip in the organization. If the people, the colleagues and the employees know that person's identity, people will say ki, this particular person, this victim also should have, must have shown some kind of signs due to which the respondent did that particular act. So what happens in that, this judgmental people are judging you all the time. They have this particular look at you. They look at you as I've said, as a troublemaker. So it's a problematic thing. It's a thing which is should be avoided. Now, how to do it? First of all, let's look at the legal safeguards. First of all, legally, what can be done? So, under PoSH, see, PoSH is the one which gives freedom and liberty to the victim to go and file sexual harassment without any kind of fear. That it only for that it should guarantee confidentiality. To guarantee confidentiality, Section 16 of the PoSH Act, it clearly mentions that any kind of publication or disclosure of the complaint details of the inquiry proceedings are prohibited. The identity, the address, the phone number of the victim, also the respondent. Remember, respondent ko bhulna nahi hai. So respondent also, witnesses also, all their names and identity should be protected, because the reprisal action can also go against the respondent also. People might look at the respondent also with reprisal, with respect to judgmental eyes and ask uncomfortable questions. And respondent can also be terrorized. Witnesses can also be terrorized. So all their identities have to be kept confidential, and it should not be shared to anybody except the IC members. That's it. Okay, even if you are like sharing information, do not reveal the identities. Okay, whenever as an advocate, when I'm discussing about any particular case, I don't tell the names, I don't tell the address, I don't give the details of the people. This case happened, this was so person so and so, but I don't take the names of those particular people. That is very much important, because confidentiality is one of the important provisions under PoSH. And if you don't keep confidentiality, there is a problem. Okay, now I will just discuss one case law, that is VK Bhosle versus NABARD. What happened in this particular case, the applicant was asked, has filed an RTI application, and he was sorting some sexual harassment details, all the details with respect to the inquiry, and some other sensitive information. So the CPIO, that is Central Public Information Officer, rejected the request, citing section number 16 of this particular act, of POSH Act, saying that there is no need to have any kind of revealing of the names and the identities and the addresses of all these people. Only the member of IC, as I've told you, should have the information. But if the confidentiality is breached, there is a penalty of 5,000 rupees, okay, as per the service rules. So if there is any kind of breach, that person should be held accountable, and that person has to pay 5,000 rupees as a penalty. There might be some people saying that 5,000 is not a big amount for many of the people, but still it's a fine. It's a different matter altogether whether we can increase this fine or not. That's a whole different thing. But yes, as per law, that person will be penalized 5,000 rupees. This ensures accountability and the people can trust the overall PoSH process. Okay. Now, what happens is there is some exceptional clause. As I've said, exceptional, that's in certain cases, specifically during a judicial inquiry, during a police investigation. It can happen that that particular sensitive information is required, but also that those judicial process also has a process in camera, or they can keep the identities of the victim, of the respondent, and of the witnesses off record, or they can do not reveal it to the media or social media or any kind of press newspaper. There is no need to do that. They can keep it up to them. They can discuss that particular case with respect to that particular judicial inquiry. Only in that particular situation you can disseminate the information. The IC members can give that information to, for example, the case goes to a court, right? If that has some criminal angle to it. Initially, IC was handling it, but later on it went to have a criminal angle. It went to the session court. Then obviously the IC will have to hand over all the details to the court. So up till that moment, it became criminal in nature. Tab tak kya hua? What happened till that time? That particular thing can be shared to the court. They have to. They have to pass on the information. This is one exception clause is there. Now, these were all the legal safeguards to protect the victims, specifically the victim, because they are the ones who are the most vulnerable to such retaliation. Other than that, non-legal safeguard is that the employer are responsible for creating a safe workplace, right? They have to conduct awareness programs. They have to constitute IC at the right time. They have to have this quarterly meetings, as Tina ma'am is always saying. Sensitization workshops should be there. Training programs should be there. There has to be an open dialogue, but at the same time, they should be proactive in nature, right? They cannot be reactive. Something happens and then they are trying to put up a certain, they're trying to keep a safe environment. After being reactive has no value. Proactively only sensitization, telling people what is wrong, what are the do's and don'ts. Tina ma'am said it very nicely that if you have a board where we can have a code of conduct, what are the do's and what are the don'ts, it's very clear. It's mentioned on the walls. It becomes very much visible to everybody, and it becomes clear that there is no need for such kind of such kind of interaction with your opposite gender. It can cause problems.